Hello, good. Oh, is this thing on? This thing is on. Good evening, everyone. Thanks very much indeed for turning out on an extremely inclement night. My name's Emily Bell. I'm director of the Tao Centre for Digital Journalism here at the Columbia Journalism School. I have quite a lot of thank yous before we get into the main programme. So I want to thank our colleagues at the Knight Institute for the First Amendment, who we're co-sponsoring this event with, and you'll be hearing from Alex Abdo, who's the senior staff attorney at Knight, in a second. I also want to thank at the top, before I forget, all of our sponsors. We're funded, all of our research is foundation funded. We are a very rare beast these days in research in that we don't take any money from technology companies, which is probably why we produce research like this about how to break their terms of use. So our funders are principally the Knight Foundation, the MacArthur Foundation, Open Societies Foundation, and the Craig Newmark Foundation. But most of all, I want to thank Victoria Baranetsky, who is the star of this evening, and she's the reason we're here, because she produced this. She had the foresight to say to us quite a long time ago, about a year or so ago, this is a really great subject for research, and this is something that I'd like to produce work on. And it really could not be more timely. There are every day new cases where we have, particularly the large platform companies, restricting the access of journalists and researchers to their APIs and their data. We like to look at this at the Tao Centre. Our colleagues at the Knight First Amendment Centre go one step further and are testing some of these concepts in law. So I think it's going to be a really rich and interesting evening. I know that I've already assigned Vicky's report to all my students for this week to make sure that they're reading it and understanding what they're doing with data. So thanks very much indeed. We'll follow the format where Vicky will present her work. And then we will have a separate panel. She will have a discussion with Jason Leopold, who I'm really grateful is with us tonight, one of the great investigative journalists. And then we'll have a panel that follows that for the second half of the evening. So with that, I want to hand over to Alex, colleague. I was going to say partner in crime, but apparently you can't say that to lawyers. And with a new beard.
Yeah.
Congrats on the beard.
We'll see how long it lasts. I'll be very brief. I just want to thank Emily and her colleagues at the Tao Center for inviting us to co-host this event, and especially Vicky for bringing us together to talk about this great report, extremely timely. And I'll just say a word about the Knight Institute since we're very, very new. We're a 2-year-old institute at Columbia focused on defending free speech in the digital age. And one of the things that we think a lot about is how journalists and researchers can study the new public square online. And that's one of the reasons we're especially excited to be here tonight and to be co-hosting with the Tao Center. So thank you.
Thanks. Hi, everyone. Thanks for coming out. Like Emily said, I realize that there are weather impediments, so I appreciate all of you being here. I'm Victoria Baranetsky. I'm a free speech and media law attorney, and I work as the general counsel at the Center for Investigative Reporting, which is in Emeryville, California, and we put out a podcast called Reveal. So before I begin my remarks about my paper, that was the inspiration for this event, I want to take a moment and thank the folks at Tao and Knight. Obviously, there were many people who were on very boring conference calls in order to make this happen, so thank you for your time and diligence. I want to start my remarks with a quote written about the First Amendment. And many of you in the audience might know that there's argument over what the purpose of the amendment is. But few contest what free speech scholar Thomas Emerson wrote nearly 30 years ago. A people who mean to be their own governors must arm themselves with the power that knowledge gives. But where do we get that knowledge, and how, and what protections are in place to ensure that the knowledge does not become corrupted or meaningless? So tonight, I hope we can have a meaningful conversation about just that. I want to take you back 2 years ago to January 2017. In today's news cycle, that's about 7 million Trump stories ago. And at that time, the press was bombarded with an onslaught of news stories. There was a question about the inauguration and how many people were in the audience, the journalists that were arrested the day before, and President Trump's verbal assaults on BuzzFeed, calling them fake news for publishing the now infamous dossier. At that time, it was clear that we were entering a new stage of information saturation. Just a few months later, the Knight Institute actually hosted an event called Legal Thinking Around the First Amendment Must Evolve in the Digital Age. Quite a mouthful, but there was a lot to say. There, Tim Wu and Zeynep Tufekci, both brilliant scholars, argued that cataclysmic changes were underfoot. That is, they argued that our attention is being usurped. The numbers were clear. According to a Forbes magazine article published just 2 years prior to that, it was said that more data had been created in those 2 years than in the entire previous history of the human race. I just love that quote because it's totally easy to jump over, but it's really tremendous, right? In those 2 years, more information than in the entire Library of Alexandria, in the entire Library of Congress, than in all of the Internet Archive. And anyway, that day at the Knight event, Wu and Tufekci argued that this boon of information was driven by real incentives. Time is a resource, Wu said, that's increasingly being mined and exploited by Silicon Valley companies that have unfettered access to our attention by phones that sit in our hands, along our bed nightstand, and every hour of the day. In addition to these corporate incentives, governments are also incentivized to produce more information as a form of censorship to flood the information market. In fact, the phenomenon repeatedly played out over the next year as President Trump continuously tweeted over national news stories. Or as The Guardian wrote, out of control, or is Trump tweeting designed to distract us? It was at that time in May of 2017 when this paper was inspired. The news had been no stranger to information flooding, right? Prior administrations had filled every single page of the Gray Lady before without a problem. But I think no one will argue that what we have seen transpire in the past 2 years of not just information flooding, but information burnout is somewhat unique. Not only is the public overwhelmed, but reporters whose livelihood depend on the news are signing off of Twitter, not engaging in stories, and heading for the literal and figurative meditation altar. While self-care and silence are no doubt important solutions to this environment, as well as technological shifts, which we can't cover here tonight, so are the changes in our legal structure. The law has an opportunity to undermine or bolster our information economy. This paper hoped to do that, to uncover some of those conversations, and it focused on 3 topic areas: the Computer Fraud and Abuse Act, the Freedom of Information Act, and sourcing. The first discussed concerns about the CFAA, which deters journalists through criminal sanctions from scraping data to report stories on corporations' data that needs to be told more than ever before. The second section discussed the limitations in new developing case law under the Freedom of Information Act that thwarts transparency. And the last discussed impediments to sourcing. Ultimately, the paper found in all 3 areas holes in the law, where journalists were unprotected from problems caused by our new information economy. I won't go into further depth because I hope we're going to discuss this with people who are much more brilliant and thoughtful than I. But what I do want to end on is a note about the importance of journalism in this flooded economy and why I think protections matter. 2 nights ago, I was in Berkeley, California, and I consoled a reporter among a group of friends who was crying about her reporting on the opioid crisis not having an impact from what she could see. The report that she wrote did not stop the bad actors, it didn't change the situation, and no legislative changes have come. She sobbed as she talked about her story having no effect, while having put her sources and subjects at risk. She felt like this information economy made it so that people just didn't care anymore, and if they did, it didn't matter because every day there was a new story to gawk at or exhale about. But in response, this group of women retorted that news stories had changed their lives, their work, and their understanding. One particular woman had explained how a news story had changed her life when she had been in PR just several years prior, read an article about climate change, and then went into advocacy work on that subject. She completely began her life anew. The point is, knowledge, especially well-reported, drudged up, sleuthed out, and investigated information is powerful, as Emerson wrote. It really matters. I think we all have anecdotal experiences from our own lives and lives of those around us. The things we read and watch, they affect us. They change our actions, inspire us, and influence us. So it matters, and it matters a whole lot. if we want to self-govern and meaningfully live our lives with intention. So while I doubt we will come up with any final resolutions on this big subject, I hope tonight we can dredge up some new conversations about how we can protect this industry and the people who care about the information within it. I think I will end there, and we will start with a conversation with Jason to begin. So Jason is a man who needs little introduction. He's an esteemed Emmy-nominated investigative reporter for this little place called BuzzFeed News, and a member of the team named for 2018 finalists for the Pulitzer Prize. Jason was referred to by Politico as perhaps the most prolific freedom of information requester. And in fact, his FOIA work has been profiled by dozens of radio, television, and print outlets. He was awarded the FOIA award from IRE and was inducted into the National Freedom of Information Hall by the Newseum. But my personal favorite award is the titles the various government agencies have bestowed upon him, including FOIA Terrorist, a member of the FOIA Posse, and one most likely to weaponize FOIA. Everyone, if you could give a round of applause for Jason as he joins us on the stage.
Thank you.
Okay.
So I think I just broke that. Sorry.
Oh, no problem.
Okay. I think it's on.
Hello.
Good to be here.
Thanks for coming. So I think one of the things that we wanted to sort of first jump into is that a lot of people talk about the waning importance of FOIA in general, right? There's a professor here at Columbia who has written several articles about FOIA being overwhelmed by corporations and sort of just not having as much of an influence or an importance, and perhaps there are other things that we could do rather than focusing our intentions on FOIA. And I wanted to hear from somebody who lives and breathes this statute just about the importance of FOIA in your career and generally what it means to journalism.
Yeah, I think that, first of all, FOIA is a crucial part of my job. It's certainly a crucial part of the work that our entire newsroom at BuzzFeed does. I mean, it's informed a number of different stories. You know, the problem is that what anyone deals with FOIA, which is the fact that it takes a long time to get documents, you know, and so, you know, the successes that we've had have largely been as a result of litigating, and so obviously going to court and litigating and then getting those documents in a far more timely fashion. But newsrooms are by and large spooked by it because they're not investing, you know, the money behind it. They're not putting money into the litigation, you know. But for me, it's just been crucial in terms of being able to write stories about Guantanamo, the CIA's torture program, even little stories about how a couple of CIA contractors hacked the vending machine and were under surveillance for 6 months. Or the fact that you know, John Kelly had referred to Elizabeth Warren as a horrible, impolite woman. You know, so it's wide-ranging in terms of what FOIA has provided us with, and I think right now, and certainly in the past couple of years, you know, the public's appetite, obviously, you know, when it comes to sourcing, right? I mean, I use anonymous sources, and I'm sure people have maybe recently heard that. But you know, the public really craves documents. They do crave this primary source material, and primary source material is crucial to really, you know, highlight what is taking place behind the scenes within the government. So, you know, fortunately at BuzzFeed, I mean, we have a budget, we sue, we constantly file FOIAs, and for me, you know, what's really important is getting enough requests in order to build this pipeline, which I've spoken to you about before. So by the time the agencies get around to it, you know, you're starting to get this regular flow of documents that you can really see what takes place behind the scenes.
So can you actually, I'm curious to hear a little bit more about that process and sort of like how you've built, if you could give maybe an example of a story or two of like how you've practically actually used the FOIA process, and how a story came out of it, maybe like one of your favorite stories that yielded from it.
There's a couple. So I'll tell a story about this, and this was fun. This is a document that I had obtained from the FBI after suing the FBI, along with a colleague, for all documents on the Trump Organization and Trump Entertainment. We received, and this was in 2017, which is about what, 20 years ago, right? So we sued the FBI. We asked them for these documents on the Trump Organization, and they sent us a document that was heavily redacted, as most are. And I think that that is a really important, thing to know about FOIA as well. Obviously, documents are going to be redacted, but the more you use the Freedom of Information Act, the more you become comfortable with documents, you can try to read, through the redactions. You can find people who actually will, perhaps as a journalist, help you with understanding what may be behind a redaction. And there's sometimes, coding in there, to understand what a document may relate to. But in this case, this was a heavily redacted document, and it was about an attorney who represented Trump Entertainment investors. And he reported that he had received a threat. He reported this to the FBI. And he also reported it to a police department. His name was redacted. The threat itself was redacted. And I was like, this is odd. So the FBI left some clues in there. One of the things that they left in was a zip code. And decided, like, okay, let me type in the zip code. It was
just the zip code.
It was just the zip code. So there was no address at all. So I put the zip code into Google, and it was downtown New York, and it showed these various businesses that were down. It was around Wall Street. It's like, oh, that's interesting. So went through them, and then found one particular banking, or excuse me, legal firm.
Yeah.
And again, this is a painstaking effort, mind you, but went through it and then found an attorney who represented Trump Entertainment investors.
Like in his bio, you saw that he?
Yeah, it was actually listed in his bio.
Gotcha.
This was one of the...
Proud member.
Yeah. So I was like, huh, that's interesting. And then obviously had his name. So we tried to contact him, and he was not discussing anything. Called his office, and there was another clue. He reported the threat to the police department in New Jersey.
Oh, okay.
So I was like, okay, so let me look this guy up. It turns out he lives in New Jersey. And I didn't know what police department because they redacted that too. So this all falls under this sort of what they refer to as like personable identifiable information.
B6.
Yeah. So it's like, okay, let's do some work here. Let's make this fun. I ended up sending a request to the police department in New Jersey. Once I found his address, it's like he lived in Holmdel, New Jersey. So I sent a request to the police department in New Jersey, and I said, I would like to, file this public records request. Give me any threats that you have received from this person, or excuse me, any police reports that you received from this person about a threat. 2 weeks later, they sent back a document. He actually received a threat from somebody who identified himself as Carmine and said, if you keep fucking with Donald Trump, we're going to come for your wife and kids.
Oh my God. Of course his name was Carmine.
Yeah. Right, yeah. So then and so the FBI redacts it. Here we have the threat. And then they also left in a phone number. And the phone number went to a payphone outside of the Ed Sullivan Theater where Donald Trump was appearing that evening when he received the threat. So this was like an amazing sort of puzzle that we put together, that we sleuthed out, all this information from from a heavily redacted document where, you can look at it and be like,
Right.
FBI is redacting it. So after we reported the story, the FBI on its own reprocessed the record and gave us,
Unredacted.
an unredacted copy of it. So that was a really fun story that sort of, opened a door into, the way in which Donald Trump sort of, and people around him were, how they dealt with these issues. I mean, another story that, was heavily based on a document was, a Inspector General report from the CIA about Zero Dark 30. And so I wrote a very lengthy story about how the CIA essentially produced Zero Dark 30, but would not have obviously been able to do those stories without that document. So I wasn't even looking for threats that Donald Trump had made or anyone associated with him had made. This was a document that came in that turned into a fantastic story.
Through litigation or just on its own?
No, that one came through. Most of mine come through. I mean, I sue all the time. So thank you to Matt Schaefer in the back, our attorney. But no, this one came through litigation.
Okay.
And when they reprocessed it, yeah, that was sort of funny. But the Zero Dark 30 one, that came through litigation as well. And I mean, the reality is that I try to constantly get requests in. So I mean, we don't sue obviously on every little thing, but we try to get some requests in that after some time has passed, you're still getting records that would be newsworthy, that would have a news value. And I think that is the unique thing about this administration, where really there's everything is really newsworthy and valuable.
Well, and it also strikes me that it's like the other thing that's helpful in these circumstances are like mistakes that the agency makes, right? And you like rely on these small mistakes to actually put together, or not mistakes, but even just sort of oversights or thoughts that they think could lead to nothing, but actually can put together a huge story.
The CIA did that. So when the CIA was accused of spying on the Senate, when the Senate was investigating the CIA's torture program, filed this request with the CIA and then again litigated to get all the records, about what took place behind the scenes as they were investigating, the allegations that the Senate Intelligence Committee was being spied on. And we ended up getting several hundred pages of records from the CIA. And I received a phone call because they had there was a courtesy copy of this shared with Senator Dianne Feinstein. Mm. And I received a phone call from a staffer who said, hey, I just want you to know that this letter from John Brennan, which is actually, that is an apology letter for spying on her, we never received that. I'm like, oh.
You're like, here you go. Yeah.
So I called the CIA and they said, yeah, we weren't supposed to give you that letter. And do you mind not posting it?
Yeah.
And I said, I hear you. And I was struggling for a month because these were very technical documents, I was struggling for a month to figure out, what's my lead? What's the story gonna be? And it was the fact that John Brennan wrote an apology letter that was never sent.
That's a great headline.
Yeah.
We actually had a similar case where the FBI, it was from 1954, a cold case, and the FBI was doing it in tranches. And for those of you who might know in the audience, the FBI is one of the longest backlogs. So they're just like going through the drudgery of these, like sending disk after disk after disk. And one of the disks was all of the documents without any of the redactions in it for that tranche. Oh. So then the reporter was able to go back to the other tranches and piece together the names that were redacted in the other tranches based on this one unsealed.
Yeah, things get through the cracks sometimes.
I'm curious, one of the things obviously so I think contextually, like one of the things I want to underscore here is like the importance of FOIA in general to journalism, and then we'll go into some more of the problems that have happened because of the increase in data. But you've spoken about this quite prolifically and substantively about how sourcing is really something that you've mined, and I think you kind of touched on it a little bit, but can you go a little bit more into depth at like how you do sourcing through FOIA and how is that process meaningful?
Sure. So without giving away sources or methods, let me be clear also that there are instances where I will get tips on certain documents that I should request. And that is hugely valuable because I don't know, for example, if there's some crazy CIA covert program taking place, or if the NSA is doing something allegedly nefarious. But there are people out there that will sometimes share some tips and say, here are things that you should FOIA. And many instances where there could be a classified program or something is classified, and it will, the fact that you file the FOIA will end up declassifying it, which will make sources far more comfortable to then speak about it. So, sourcing and FOIA to me go hand in hand. I mean, I try to essentially, I spend a good part of my week trying to cultivate new sources, and I think that it's very interesting. I mean, I will admit that I often get people who, when they agree to sort of have that initial conversation, they're like, you're the guy that got Hillary Clinton's emails. I'm curious, why did you ask for those? And so that will lead to a conversation which ultimately leads to a new source. To the question about what's important or why it's important, I mean, it's I think that it's really important right now based on the fact that there is this world of lies. Everything just, it seems very difficult to trust anything that certainly is coming out of any of these agencies, any talking points that they're having about various programs, that to try and pry loose these records. And so once you get those records, it's important to then find the individuals who can speak authoritatively about it.
And I think there's something really comforting in seeing that name in black and white, right? Like you get a paper, it's right there. There's no really contesting what that name says. Whether that name is true or not is a different story, but like there you have it in black and white.
Yeah, and there's instances where where I often get records and there are names in there. Sometimes, here's a great example. I have a cache of records from the FBI about the Trump casinos from back in the 90s. Yeah. And there's a number of FBI agents whose names aren't redacted. They're retired. So I'm able to then go track them down, and they're willing, to speak about, here was my experience, in dealing with, Donald Trump and his businesses way back when. But I mine that information to try and find people. So
that makes sense. So I think that there are kind of like three buckets where it sort of was revealed that the more information we have, somehow this information economy has made FOIA a little bit more complicated. And so one of the cases is actually similar to something that we are dealing with at Reveal, where we asked the ATF, the Bureau of Alcohol, Tobacco, and Firearms, for a list of all their trace records. But because those can't be disclosed in total, we just asked them to redact the column of the trace number of the individual gun, so there would be no identity of anyone revealed, and just so they could have the aggregate number of guns that go back into the marketplace from law enforcement. So law enforcement resell their gun into the marketplace, and ATF has that data. And so we were asking for that database with just the redacted column. And so the agency came back and said, actually, if you redact a database, if you just redact a column, or ask us to reconfigure it and give it back to you, that's the production of a new record. And under FOIA, you can't disclose or you can't make the agency create a new record. And so increasingly I've seen cases where there have just been agencies saying, sorry, we're just not going to touch this database and we're not going to give it to you. I'm just curious, like, have you seen this trend as well? And
I've
do you have reflections on this?
Yes, no, I mean, look, I think the reality is that there are certain agencies that will go out of their way to try and thwart the Freedom of Information Act and ensure you do not get records. And right now, the Department of Homeland Security and all of the agencies, sub-agencies that fall within the Department of Homeland Security, they're doing that. I feel like I probably shouldn't say this, but
do it. Close your ears, Matt.
Yeah, I probably shouldn't. So it's live streamed anyway. So, but yes, they are. This is an agency right now that's essentially saying that, for example, everything is too broad, right? Sorry, your request is too broad and burdensome. And it would require us to create new records of what you're asking for. And the problem is, at least from journalists, right? The public, corporations, that's different. Journalists get fed up, and it takes a lot of work to, one, understand what the law says and how to appeal it,
right.
So, and that's the thing about FOIA, is that this is a battle. I mean, it's not supposed to be this way. But particularly when you're talking about databases, I ask for videos a lot. Mm-hmm. Videos are very, very valuable, and as I'm sure you can imagine, they don't come out that often.
Right.
And one of the issues that some agencies, claim they have is like, well, again, we can't redact a video. Oh, yes, you can.
Yeah.
Yes, you can. You can do that, and that is, again, to try and explain that to them on the phone. That's just difficult. I mean, you end up in litigation in order to do that. But I've seen increasingly that the Department of Homeland Security is trying to, thwart the release of records by essentially inventing new rationales for it. And that becomes, and then, I end up FOIAing the processing notes, and you find out that there's a directive about this
right.
is how we are handling
this issue.
This, FOIA. But that is historical, and I think that it gets to, something we discussed where, there were amendments to FOIA.
Right.
And
in 2015.
Right, and they have not been enforced, so the agencies are essentially able to come up with whatever reason. And if you're a journalist in a newsroom and you're busy, what are you going to do with that? Hopefully you're in a great newsroom, like we have at BuzzFeed, where you have lawyers that will advise how to, challenge that.
I mean, what do you, I want to go to the other trends too, but what do you say to reporters who don't have those, attorneys at their fingertips like you do?
I mean, I think that the great thing right now is that, one, is that there's a community, right? I certainly, as long as I've been doing this work, particularly FOIA work, it was very small, but there's an incredibly large FOIA community out there where you can reach out to people. People reach out to me all the time and say, can you help me with this appeal? So, I mean, that's really what I say. I think that there are, certainly some clinics that, that exist, but it's really sort of keeping in touch with that community. I think that social media has been fantastic for that, particularly Twitter, where you can, where people will discuss, like, I have this is the response that I received. I don't know what to do, and then suddenly you can see that they're being advised.
I'm laughing because one of the reporters in our newsroom, her first FOIA of the year came back, and it was a CD that was broken in half.
I saw that on
Twitter.
Twitter.
And then put it back
Yeah.
in the thing, and they sent it to her, and she was like, "First FOIA of the year, broken disc."
Right.
And this is a Pulitzer Prize finalist, and she said, "This is my most retweeted tweet I've ever gotten."
Yeah.
And I was like, because you hit the FOIA community
Right.
on Twitter, like
And
you tapped.
It's a really great community. It's a
Yeah.
fairly large community, and everyone sort of has a common goal, which is to ensure that there is an open, transparent government.
Yeah. Another thing that, and I want to hear your reflection, especially on this one, is the trade secret argument being raised
Right.
increasingly. So we have a case in Texas where the legislature actually passed a law in Texas requiring for football injuries to be logged. And so one of our journalists asked the University of Texas to disclose the database with all the number of head injuries at the University of Texas. The university comes back and says, sorry, we can't disclose this to you because the database itself is a trade secret. So if we gave that to you, we'd be giving you the technological and data of how we, it's essentially an Excel spreadsheet.
Right.
And I've seen that increasingly, and I think it almost seems like the governments are sort of getting a tip from corporate responses in public records requests, and I'm curious, if you've seen this trend as well.
I mean, as far as a trend, I have not. I mean, this is the Reagan era rule that what is known as reverse FOIA.
Right.
Right. So I haven't seen it as a trend, but I mean, certainly this gets down to how do you challenge that, right?
Right.
Because it's really also important to know that I try to speak to FOIA officers or analysts at various agencies. Right now, there is such a backlog of requests that many of the folks that are handling that, they're contractors. The State Department, for example, had I don't know if it was ex-diplomats or foreign service officers that were handling it, who are not well trained in FOIA, right? And so if you're a reporter and you understand, well, wait a minute, how are you determining that this is trade secrets? And I want you to put that in writing.
Right.
You start speaking to them about it. They're like, well, that's what I was told. It's like, no, that's not how it works. But I think that is really important to know, who the person is that's sort of telling you that. But I mean, trade secrets is I've dealt with that certainly with the EPA when BP, the oil company, was suspended from contracts, and I wanted some documents that revolved around the investigation, and they said, well, that's a trade secret. We have to get BP's permission.
Right.
And then they took 18 months, because I didn't sue over this, it took 18 months, and by the time they gave me the documents, BP was reinstated for their contracts. But that is one where, again, you have to know how to challenge that.
Right.
And understanding that going into it, that when it comes to any company, for example, Facebook or Google or any major corporation particularly where you're asking for databases, they assume it's a trade secret because you're asking about a company. But I think that it's unique also to sometimes with databases, because even though that is not something that should take a long time for an agency to process, it really isn't.
Right. No.
It is still tech-wise foreign to them. It's what database, where are we giving away our hard drive? They don't understand exactly what that requires.
Right.
So they're getting this information from a manual, from a directive, or
Do you find you're coaching the FOIA?
Definitely certainly at State Department right now. Yes, and also the Army.
And are there FOIA officers that you've known them for multiple years, and they're like, hey, Jay,
Yeah. Oh,
man.
yeah, no. At DHS, there's a woman at DHS who will say, hey, got your request, I'm going to have to give you the burdensome. And I said, I'm going to sue. She's like, all right.
Of course you are.
And she's like, okay, but I had to do this just to let you know. And then she tried to tell me, here's a way to avoid, burdensome. You have to use conjunctive phrases.
Are you kidding?
No, and I'm like, why? She's like, that's what we were told. And the problem is that, but here's the
and then you have to turn twice on your left
right,
leg.
yeah, it's like, pray and throw a penny in the fountain. The problem is that she told this to me, but other requesters are not being told that this is the reason that they're giving, that they're handing out these burdensome responses. And again, they're trying to reduce a backlog, and the way that they're doing it, aside from apparently hiring some contractors is also to deny requests outright. But I do feel like I've been coaching people at the State Department because they're making phone calls and they're saying that your request is not a proper request. And I ask them what's wrong with it, and they tell me, and I say, well, that's not what your regulations say. But again, regulations, right? I mean, how many people know about that? And I think that is really what's important now as these agencies get more and more requests, and particularly as journalists file, more requests for records, is crucial to really understand what the regulations say, what the system of record looks like, in order to perhaps even perfect the request and to be able to challenge it.
Yeah, I think that's really apt, because if you're gonna, make it go away, then you got to know what it is.
Right.
Another thing that, I think we've noticed a lot, and I'm curious to hear your response on this, because I think this is an old problem with like a new trick up the sleeve, which is the cost for FOIA requests. And so generally there should be no cost except for, what goes into the production. But there was a really great case from about a year ago that was in the report where Quartz had filed. Quartz is like a small business news site, and they do incredible work, and had asked one of the federal agencies for some records. And the agency comes back and they go, actually, this is valued at, I think it was like several $1 million to private companies. And so because big data is so valuable today, they came back to Quartz and were like, give us the 1.7 million bucks. And Quartz goes, are you crazy? This is a public record. And Reporters Committee fought it, and they actually, they helped Quartz win. But I have also seen we've seen in our newsroom certainly like the costs, especially with databases, because of the tech lag in these agencies and the inadequate training, requests for like $10,000, I mean, not as much as $1 million, right? But like $15,000, $20,000 to give a request response. Have you seen this as well? And
yeah, I've seen that, so to be clear, that is something that has often been used on the state and local level, right? Where it's going to cost $2,000 to go through 10 emails because we have to pay our attorney, which is ridiculous. And so the whole rationale behind it, it's clear. They're trying to, again, thwart the release of records because most people won't pay for it. I know this may sound conspiratorial, but it's true. I mean, I've seen it sort of in the documents where they're trying to figure out how to not, turn over records. But
because it's easier also for them not to turn over. It's just
it is,
easier.
and if you look at, in my spare time, I sometimes look at administrative case files.
For 2 minutes.
On the weekends when I'm taking a walk. I will look at the administrative case file in FOIA because I do look at the FOIA logs. I'm very interested in what other people are requesting. I'm very interested in what the corporations are, the private firms are requesting. And when you look at some of these administrative case logs, when it goes back to journalists and there's costs, they're not, they close it. The case is closed. They're not releasing the records. And because there's really no challenge to the cost. So if it's $2,000 or $3,000, the likelihood is that a newsroom is not going to pay for it. I mean, it's just a reality.
And the corporations are paying for it, just out of
they will pay for it. Yeah. And I think again, it's that this is a case where the U.S. Army, I asked for records again. It was revolving around the treatment of detainees in custody of the Army, and it's very important to also note that. Even though we get a fee waiver as journalists, you still have to put a justification in, right? And that is something that is not often done. It's you can't just say, I'm a journalist, give me the records. It's like, well, why should we give you the records? How are you going to use the records? What's the public interest, right? And so that's an argument that really does, that you do have to make with some agencies. But the Army said, yeah, we found some records. You're not getting a fee waiver because we don't think there's a public interest in how we treat detainees. And I was like, what? And I appealed it, and they actually, upheld the denial. And I was like, oh my God! And I was so mad. I mean, I was like cursing. I was like, you and they,
Exactly.
and so at that point, they made it clear, you can litigate this. But I didn't, for me, that was where I had to weigh,
What the
what the value was. But, so again, these are particularly in the past couple of years, I don't think that it's as, it's far worse than it was under the Obama administration. I really don't.
Yeah.
I think that, one of the things that we're dealing with is the massive backlog. But there are new and unique ways that agencies are trying to thwart the release of records. And, one agency in particular, like Health and Human Services, which is a small agency that really was not getting that many requests, that's being bombarded now.
Right.
And there is internally, directives on how to handle, FOIAs, and costs are one of them. If the journalist or the requester, if you're a journalist, and you are not stating why you deserve a fee waiver and what the public interest is, you're going to be saddled with, the processing costs.
Unbelievable. I think just sort of anecdotally, we've seen ICE, I think they also have like such an immense backlog and just several times just close the file without even responding to it, which I think before then, you'd at least get like a denial, some kind of like, pat response, and it's now just like the file is closed. I think another, one of the last things that I think is interesting on this subject is, we had sort of, I think not just the reverse FOIA, but circumstances where there are more federal contractors, right? More companies that are acting as arms of the government, and then they're able to use a trade secret response too. So we had this one case where our reporter asked for the diversity reports from federal contractors, and the agency came back and then told the reporter, in fact, sorry, diversity reports on these companies, Silicon Valley companies, Facebook, Twitter, et cetera, these are trade secrets. So somehow, statistics on diversity were trade secrets. And so no longer do you have this sort of public accountability.
Yeah. I do think with those types of requests where, particularly with Silicon Valley companies, it's really important to try and get those sort of processing notes, to understand how, if in fact you decide to litigate or take it further, but to really understand what is taking place behind the scenes. That, is that still on? Yeah. In order to know, essentially once the request gets in, what are they doing with it afterwards?
Yeah.
Who are they calling? How is it? Because I can tell you, it's not just, oh, you're asking for diversity reports, trade secret, and as we've seen with Amazon right now, where, it's not a surprise. I think a lot of people are surprised that Amazon is looking to, essentially say that any FOIAs about what they're building
Right.
Would be exempt, and that is historically, may be the case, but the fact is that there's also, a lobbying effort taking place. So to really, to understand and become sort of, a little bit of an expert behind it, to know what's taking place behind the scenes through the processing notes is, could be hugely valuable.
And how do you get the processing notes?
I mean, essentially, you file the request, you get the request number, right, case number, and you wait a little while, and certainly, if you get the denial saying it's a trade secret, you just say, I want all the processing notes, relating to case number.
X.
And again, this is it gets back to what I said earlier, is that this is really tedious. I mean, and many of us, particularly now, don't have the time, but it's crucial in order to really understand how the agencies right now are treating FOIA, and as I mentioned, that there's no enforcement of the amendments that were implemented, and the memorandum that Obama issued that was codified into law. Yep. So to understand what's going on behind the scenes could be beneficial in understanding how to get around it.
So I want to open it up to the audience, but I have one last question for you. If you had like one dream amendment or like change that you would make to the statute, what would that be in your?
to give me everything, the give me everything amendment. I think that, you know, certainly the most annoying amendment is the deliberative process, you know. And
Can you tell the audience?
Yeah, it's B5. It is where an agent, I mean, there are two parts of it, right? There's the attorney-client privilege, where, you know, an agency may be providing advice, legal advice, and then there is, well, these part of it which is relates to deliberations. And what the hell does that mean? You know, where they try to use it and say that, you know, we're trying to provide candidate advice. It may not be legal advice, but you know, it could be like a draft, for example. If you ask for anything that's a draft in draft form, a draft memo, you know, they refer to that as deliberative. So I think that just changing, you know, that deliberative process, because it is used in a way, yeah, and in an effort to withhold, you know, vast swaths.
Yeah, because you just put
records.
draft on the top, and then basically, if it's a
Right.
draft,
Yeah.
you don't have to disclose it.
Yeah, I mean, I've received emails where they say, and it's clear it's not a draft, you know, draft, I think it was a John Kelly email, you know, where, well, I received this John Kelly email where he says, this is great, by the way, if I can just throw in a little anecdote. He was writing an email to someone else where he said, FOIA is real. And essentially saying, avoid FOIA, because it's real, and this will get released. And I got
My God.
obviously that email where he says FOIA is real through FOIA, which was really fun. But yeah, I think that
Did it like validate your life choices right there and then?
yes, it did. I was like, oh, this is so cool. Hang it up. I think the Reporters Committee turned it into a sticker, which was nice. But, you know, so yeah, I would say the deliberative process. And then, you know, I mean, it's hard to say. Certainly when I'm looking at the intel agencies, there is a constant use of B1, you know, withholding things on national security. And then, you know, it's interesting. After litigating, you realize, you know, when you can challenge some of these withholdings, that, well, there really is no national security. Can I throw in one more anecdote?
Yeah.
One of the most valuable, what I have found, one of the most valuable sets of documents at all agencies are Inspector General reports. And Inspector General reports really kind of lay bare what takes place behind the scenes at a government agency with regard to waste, fraud, and abuse. In some agencies, they're classified, such as the CIA. So I had sued the CIA for 5 years worth of Inspector General reports. And they turned over a bunch. And there was one report that was completely redacted. And all it said was, killing of an animal, the illegal killing of an animal on federal land. And I'm like, oh my God, what's that? And they withheld it, they withheld the identity of the animal. Identity, is that right? Or the breed, excuse me, of the animal on national security grounds. I'm like, this is fucking insane. This is crazy. So I was like, I need to find out what this animal is. And they said, we can't even tell you where the animal was killed, because then you'll be able to build a mosaic and figure out what kind of covert program we have going on. I spent 2 years, no joke, because this was more like a pet project, no pun intended at this point, where I was like, I need to find out the name of this breed of animal.
The genus.
Yes, the genus of this animal. So finally, you know, after the CIA is like, are you guys done yet? Are you done with, you know, litigating?
Yeah.
I said, look, we will stop litigating the rest, because I pretty much at this point had everything I needed, but we want to know about this animal. So it turns out it was a deer, and it was basically, looked like some CIA officer hunted it on a farm, on the farm, the CIA farm where they train officers. So for 2 years, like, I thought this was like, oh man, they had this covert program in like some other country, and they, you know.
I'm like, is it the Cheney Deer?
Yeah,
Like, what is
right,
it? Like,
yeah. But the fact is that they actually referred to it as national security, and there was no, like, what, they wouldn't even, you know, I mean, they made it clear, like, people would be upset if they found out we killed an animal, you know, because we're the CIA and we're not supposed to be doing bad things. And that's seriously how they were referring to it. It was hugely satisfying to force the CIA to tell us that somebody killed a deer. So I find that to be a big success.
That's worth every
Yeah,
penny.
yeah.
I love it.
Yeah.
I want to open it up, or maybe just one question, or no? from the
Sorry.
audience?
Sure. I think maybe we can take one question while we set up for the panel.
Sounds great.
Two.
Does anyone want to take the opportunity to ask Jason inappropriate questions?
All right, that's how I like it.
Okay.
Yeah, good.
I can't tell if this is working. I guess it is. Hands anywhere?
I have a small question.
Here, let me.
I can talk loud.
Okay, we got a live stream.
Just a small question is, New York City has open data. Does that come in handy, and is there going to be other places that do this? Is that common? You know anything about that?
That's a great question that I actually cannot answer. I'm not. I mean, I understand that in terms of open data, what are you referring to specifically?
I actually went to it. Just a lot of bits about what goes on in the city is in open data, where you can
Like open source?
Open source, and you can log in and check it out. You can even trace all the taxis all over town of where they go.
It's the New York Open Data Portal.
Okay.
And
I live in LA. We don't have that.
Yeah.
Sadly.
I could make a brief comment to that. I'm the assistant director of the Tao Center. I actually teach data journalism here at the school, and I'm very pleased to be involved with this event. I think if I may refer to the work of another investigative reporter, which is that while it can be useful, it's all the things that somebody wants you to have. And so while it can have value, I think sort of to the point of our conversation here, there can be limited value in what somebody's willingly going to hand
Right.
over.
Makes sense.
So, any other questions? No? Really? All right. Well, if we could thank Vicki and Jason very much. Taking time away from many other activities. And I think we'll just take this moment to transition to the panel.
Yeah, that's great. Should I was going to introduce the next panel. Should we? Okay.
Why do you do it with your mic?
So for the next panel, we're very lucky to have 3 all-stars here today. First, we have Aisha Bandari is a staff attorney at the ACLU Speech, Privacy, and Technology Project, where she works on litigation and advocacy to protect freedom of expression and privacy rights in the digital age. She also focuses on the impact of big data and artificial intelligence and has litigated cases including Sandvig v. Sessions, a Computer Fraud and Abuse Act case, which we'll be talking about tonight, and Al-Assad v. Nielsen, a challenge to suspicionless electronic device searches at the border. Next, we have Surya Mattu, is an engineer and journalist based in Brooklyn. He works as a data reporter at Gizmodo Special Projects Desk and is a journalism resident at iBeam. Previously, he was a contributing researcher at ProPublica, where he worked on machine bias, as well as many other projects, and some of his pieces have even been Pulitzer finalists. Last, but certainly not least, we have the esteemed Alex Abdo, a senior staff attorney at the Knight First Amendment Institute. Prior to joining the Institute, he was also a senior staff attorney at the ACLU and has been at the forefront of litigation relating to NSA surveillance, encryption, anonymous speech online, government transparency, and post-9/11 abuses. More recently, Alex has litigated on behalf of Knight for journalists and is currently working on Knight's work involving the CFAA and petitioning Facebook, which we will discuss here this evening. Before we jump into this panel, really want to briefly discuss. So the first panel we were talking about, the concerns with data and FOIA, and this panel is focused on the Computer Fraud and Abuse Act, and I'm not sure if everyone in the crowd knows about the Computer Fraud and Abuse Act. Essentially, it was a statute, an anti-hacking law that was inspired by War Games, that movie from the 80s that Matthew Broderick was in. And at that time, there were only actually 2,000 computers connected to the internet in total. And there were concerns about hacking at the time, and for this reason, the law states that it's illegal to intentionally access a computer without authorization. But what without authorization means is not clearly defined, right? And so journalists are often afraid of breaking that statute because it comes not just with civil penalties, but criminal penalties, right? So there's a concern that journalists might actually face jail time for this. But some newsrooms have still taken risks and reported wonderful stories, which we will be hearing a little bit more about tonight, and found roundabouts. But I'm going to first join the panel up here. So, Surya, I was wondering if you could sort of start us off and speak more broadly in terms of data journalism and, you know, its value, especially given the fact that the CFA has inhibited, if not, you know, robustly sort of amputated, I think, data journalism in a lot of ways. And I'd like to just sort of hear your, like, you know, introductory remarks, given that this is like the land that you live in, and these are your people.
Sure. I should first say that I need to do two things. One is update my website, which should say that I work at the markup, not Gizmodo. That's my bad. And then I'll say that, yeah, so the CFA is something that's always like looming over our heads. And I'll just give like two different like types of stories in which, so for one thing, I think, so I have a background in engineering. I didn't ever plan to be a journalist. It's just that technology is so embedded into society now that there's actually like, I kind of think of my source as like network infrastructure. And like that's kind of how I fell into this. It wasn't that I was planning to be a journalist. I just knew how to talk to these computers in a way that we could ask meaningful questions. And I think the ways in which that comes up is, I can give two different examples. One is in machine bias in the story we did at ProPublica around risk assessment tools, along with the FOIA, which we filed, which is where we got the scores for the risk assessment tool that was being used in the, do people know the story, or should I?
No, I think introduce the story.
Yeah, sure. So basically there's a story about a risk assessment tool used in Florida, in Broward County, called Compass. And basically it was a tool that was being used to determine someone's likelihood to commit a crime again. And when we did an analysis on this tool, we found that African Americans are twice as likely to get a high score and not commit a crime again. And Caucasians are twice as likely to get a low score and commit a crime again. So we basically found like there was like bias in this algorithm, well, bias in the data set probably that was trained in this algorithm and the system in which it was operating in. And the way we could do that analysis was first using FOIA to get the scores from Broward County, but then we also had to scrape all the information of the people whose data we got. So basically you got a spreadsheet with 15,000 people's scores. Then we had to see what they got those scores for. And in order to get those scores, we had to go to Broward County's website, to the clerk's office website, and basically for each person see what case caused them to get that score and did they actually commit a crime again. So doing that manually for 15,000 people would be almost impossible. So we used, I wrote a scraper and we did some data collection to do that. Of course, this is in violation of the CFAA, but unfortunately there's no other way to get that data. So this is kind of one of the tensions that we kind of come up against all the time is how do you collect data at scale that exists in a way that, and it's kind of this weird thing where I'm allowed to do it if I use my hand and mouse, but I can't write a program to do it. And it's kind of confusing why that's the case other than just like slowing me down. So that's one place in which it comes up. Another kind of angle, another two ways in which it comes up is I did a story at Gizmodo with Kashmir Hill on smart homes and how they leak data about us. And in that, we basically did this thing where we made a special router that allowed us to collect all the network traffic. Basically, we could see everything the ISP could see, and the way we framed that investigation, we were interested in everything your ISP could sell about you based on what your smart home was, the data it was creating, right? And in theory, by doing that, we were in violation of the terms of service of a lot of the companies whose devices we had. And if they wanted to, they could, in theory, prosecute us under CFA, I think. But I'll let the lawyers correct me about it. Yeah.
All right, don't worry.
But yeah, so in terms of the spectrum in which the CFA comes up, it's really pretty broad, and it's just because of the way technology is kind of influencing where the impact technology has in society.
How many stories do you think that you haven't pursued because of the CFA, out of curiosity?
A few, but I've been I mean, I've done weird things. I was once on a boat in front of Mar-a-Lago sniffing Wi-Fi, which is definitely in violation of some sort of CFAA thing. But I think for me, I've kind of just trusted the institutions I worked for, and I worked for big institutions which kind of welcomed the fight. And I think that's the difference, that not everyone is in that privileged position to actually be able to take on that risk. And I mean, I'm on a visa here, so I was exceptionally worried about it. But I trust the people I work with, and that kind of protects me. But overall, it comes up like every day. Like when I finally understood what was considered in violation, I had sleepless nights for a long time.
So I'm curious, there have been, maybe perhaps to give you more sleepless nights, I think roundabouts that different organizations have come up with, right? And ProPublica came up with one, and I'm wondering if you could sort of speak to that example, because I think we'll return to it later this evening.
Yeah, so one of the ways in which we collect data is we crowdsource it, right? So when you can't get data from a company, for example, political ads that they're selling, or ad categories, or when I was at Gizmodo, we did a different version for Facebook's People You May Know algorithm. I'll use that example because it's easier to explain, but basically, Facebook has this algorithm called the People You May Know algorithm, and this is basically the way they suggest friends to you. So when I worked at Gizmodo, Kashmir Hill was very interested in understanding how Facebook suggests friends to you. And we found a bunch of really weird stuff, and overall what we found was that algorithm actually harmed members of the LGBTQ community and sex workers because it didn't give you an easy way to opt out of it. You didn't know why people were being suggested to you, and there was no way in your privacy settings for you to disable that feature. Even though we asked Facebook about it and they said you could disable it, it turns out that setting doesn't exist for everyone. So what we ended up doing to kind of highlight this story was we built a tool that let users collect their own People You May Know data. Now this is kind of tricky. The reason we built a tool was because Facebook doesn't have an API, which is kind of like a technical way or a code-driven way for a company to let you access their databases. They don't have an API for People You May Know. So there's no way for you to actually collect that information about yourself using software programs, so you have to scrape your own data. So we made a tool that allowed us to do this. And the reason we did it was we just wanted the anecdotes. We wanted to hear from people who said that they had restraining orders against people who were being suggested to them, or people who were trying to keep their cis identity and queer identity separate and couldn't do so. And as soon as we made this tool, Facebook told us we were in violation of their terms of service, and we had to take it down, even though we had gone to all these lengths to actually make sure it was as compliant as it could be. And that's something that could 100% come under the CFAA.
Right. So just to be clear, right, people have gone to the public and said, instead of us scraping the data from your site, we're going to outsource this to the public, where they will piecemeal collect this information and then give it back to the journalists so they can't be liable. But what you're saying is, even in those circumstances, Facebook has reached out to sort of quash those roundabouts that really you potentially should not be in violation.
And I believe we're in violation, and the users who use it are also in violations of the terms of service.
Because why not get everybody? Right. Yeah, great. So Alex, I'm wondering, I think this is a great time for you to jump in and sort of speak to what you guys at Knight have been doing about this problem, and particularly approaching Facebook, and sort of just speak to the...
Yeah, absolutely. Thanks for having me on the panel. Delight to be here with my former colleague Aisha and Surya. So one of the most important questions that journalists are asking right now is, to what extent are the social media companies influencing public discourse? To what extent are the algorithms behind Facebook's decision to show you this post versus that post, to suppress one message or prioritize another? To what extent are those decisions deepening our social divisions? To what extent can they be manipulated to influence our elections? Those are extremely important questions that journalists are trying to ask right now, but the algorithms that they're trying to study are extremely difficult to study directly. And as a general matter, if you're trying to study these sorts of algorithms, what are called machine learning algorithms, you generally have to study the outputs of them. You can't study them directly. And the way journalists want to do that is through using tools that Surya has talked about. They want to collect a large set of the outputs of one of these algorithms and study whether bias has infected the system, to study whether they're promoting one outcome over another that may be socially divisive or the like. And they're limited in their ability to do so because, as Surya was mentioning, Facebook and Twitter have terms of service that prohibit the use of many of these tools. And the two main ones that journalists and researchers want to use are tools that allow automated collection or scraping. So it's a tool that would literally just scrape publicly available information from the site. or the creation of what Facebook calls fake accounts, what in the context where we're interested in them, we call them research accounts, where journalists may throw different profiles at Facebook's algorithms to see how it reacts. It may create a profile, the journalist may create a profile that resembles a Democratic voter and see what ads that person is shown. And maybe they'll create a profile that resembles a Republican donor and see what ads that person is shown. And then they'll do the spectrum of profiles to see how the system responds to those different profiles. And both of those tools violate Facebook's terms of service. And yet, if journalists and researchers were able to use them, they would yield extraordinary insight into how these platforms are influencing society. And so we proposed to Facebook in August of last year that Facebook amend its terms of service to create a safe harbor for bona fide journalism and research that would otherwise violate the terms of service, but that is conducted in a privacy-preserving way and that would benefit the public interest. And we are in ongoing negotiations with Facebook about this proposal, this proposed safe harbor. Not to spoil the ending, but Facebook has so far resisted our proposal that it amend its terms of service, and we're thinking through what our next steps are. But we're still kind of in the midst of those conversations. And it's an enormously important question because so many of the decisions that are influencing people's lives, whether it's the social media companies' decisions about what public discourse online looks like, or the decisions of the Bureau of Prisons when they make risk assessments that they provide to judges, like the report that Surya was talking about. They're outsourcing those decisions to algorithms that are very difficult to understand. Mm-hmm. And if we're to have any hope of understanding them, we need journalists and researchers empowered with digital tools to study these digital problems. That's what motivated our involvement here, and that's what led to this proposal to Facebook.
So, I mean, not to handicap your ongoing conversations, but I'm wondering if we could sort of get a light into that a little bit. Like, how have those conversations been going? Mm-hmm. What level of productivity have they had? Or, can you comment a little bit more on that conversation?
Sure. So, Facebook in our conversations will say two things that one struggles to reconcile. One is that they value journalism and research focus on the site. And the other is that they will never say publicly that scraping the site, which is the foundation of all this important journalism and research that they have lauded, is acceptable. And they are struggling, I think, themselves to reconcile these two competing interests. And their tendency, their inclination, is toward what they have called individually managed relationships. They want journalists and researchers who are studying the site to go through approved channels of access, whether it's the APIs that Facebook makes available, and they do make available some limited APIs that you can use to study the platform. They're mostly made available for commercial purposes. So if you're a developer and you want to release an app, and through that app you want to have access to your users' data so you can monetize it, Facebook says great. But if you're a journalist and researcher, you have to kind of
apply for a press pass?
You have to cast your project, your investigative project, as a commercial one for approval through these API processes. And journalists don't always get through, and we've heard of a number of stories where they don't get through. But that's the direction that Facebook is going. And they have another project, which is a laudable one but a limited one, called Social Science One, where they're working with the Social Science Resource Council to make data sets in some capacity available to researchers. And they've been talking about this for 2 years now, I think. It's been funded by many of the organizations that fund both the Tau Center and the Knight Institute. It's a laudable effort, but it's a limited one, and it hasn't yet really gotten off the ground. And if all the research that were important to be done about Facebook could be answered through the tools that they at some point plan on making available to researchers, that would be great. But I don't think that's the case. And in the meantime, every single day, journalists and researchers are having the internal conversations that Surya was alluding to. And we've spoken to dozens of journalists who do this sort of work, and they all will say, we think about terms of service and we think about the Computer Fraud and Abuse Act every time we undertake a digital investigation of a large company. And they answer that question differently depending on the size of the institution, whether they think they can weather the storm, so to speak, They take into account the public interest of the investigation they're undertaking. And they take into account the likelihood that these companies are going to notice their project and come after them. They often will change their projects to make them less risky from a legal standpoint. Sometimes they'll abandon them altogether. But in either event, the public is denied access to important journalism that would shed light on these companies.
Yeah, I think what I love about your Safe Harbor project is that it takes that decision-making process out of Facebook's hands, right? It almost is like you're applying for a press pass every time, right? And you have to prove your story to Facebook, which has questionable, adeptness at being able to determine who a journalist is, right? Within press law, there's been an ongoing, right, definitional question of who the press is. And so Saria is nicely backed up by the markup now and ProPublica before. But what if you're a freelancer, and I think you guys actually are representing maybe some, what if you're a freelancer that doesn't have an institution backing you? How can you justify your work to them? I'm wondering if you could answer one more thing that's related to this. So, we were talking about these circumventions that Saria and others have used to get a roundabout with the CFAA. But then recently, I think that Facebook, it was announced, had actually taken away some ability to do that. Mm-hmm. And I'm just wondering if you could talk about what happened, and also just the need for accountability given those measures, et cetera.
Right. So this is a story that came out yesterday, reported by ProPublica. One of the tools that ProPublica has developed, which has been a foundation for a lot of the reporting on Facebook's political ads, is a tool that allows ProPublica's users to install a plugin on their browser that collects ads from Facebook's site and then donates those ads to ProPublica, so ProPublica can study what ads people are seeing on the site, and it can analyze who's seeing what ads and for what reason. ProPublica had been operating this since I think the time you were there for a few years now, and Facebook quietly for a long time has been telling ProPublica, this violates our terms of service, you should take it down. But they had held off on, taking further action until about 10 days ago, when they finally changed the way Facebook's site works, so that the tool no longer works. It's essentially like a code-based barrier to this particular tool. And they shut it down. And as a result, ProPublica's tool has been shut down. Mozilla, which not a lot of people realize this about Mozilla. Mozilla, supported the development of Firefox, but they also have a research arm called Mozilla Foundation, and they're very interested in studying the health of the internet. And they also had a political ad collector that has been shut down. And there's a British nonprofit called Who Targets Me that has also been trying to help users understand who's profiting from the data that you give up when you use social media tools. All those have now been shut down. And the report just came out yesterday, and Facebook's response was this was a routine update to the site meant to make ad blocking more difficult. And
care about journalists.
We care about journalists, but we also care about privacy. And I have a lot of thoughts about it. I have a long thread on Twitter you can read where I explain why I think their excuses are not particularly persuasive. But that's, the future we're heading to, unless something changes, is one where the large private companies that control the spaces that have kind of taken over what used to be public spaces are now both the subjects of news stories and the gatekeepers to the information that would be the basis of those news stories. Yeah. And I think that's an untenable position.
So that's pretty desperate. So I think when we get to that situation, I feel like every journalist really needs a good attorney. So Aisha, I think we're going to turn to you now. So we're in this perplexing quandary, right? And I want to hear from you, what's the state of the law? So I gave an introduction of what the CFAA says, right? Without authorization is the language. But so what is the state of the law around the country right now? And, where do you see things going? And tell us about your case in particular with regards to this.
So the state of the law with respect to the CFAA is unclear, uncertain, developing. And specifically with respect to terms of service violations, which is, I think, the most relevant to the kind of journalism we're talking about. Some federal courts in some jurisdictions have said that terms of service violations alone can't be actionable, can't render you liable under the CFAA on a variety of grounds. because there are a lot of problems that stem from that, including the fact that if terms of service violations are criminal violations, probably every one of us in this room has committed a term of service violation. They're so broad, they're written by corporate lawyers who have no incentive really to limit what they are. So as soon as they write them and they're incorporated into the CFAA as a criminal prohibition, that creates all kinds of problems. The common examples being anyone who's ever used a dating website and maybe been less than truthful. And if those sites have a requirement that you only provide truthful information, that's a CFAA violation. A lot of common terms of service prohibit copying and sharing information from the site, including manually. So if you've ever copy-pasted something and put it in an email to someone else, you've probably committed a CFAA violation. I've even seen the manually copying information to be interpreted as taking notes of what you saw. So there's clearly problems with the CFAA, and some courts have recognized that and limited the scope. Other courts, however, have held that terms of service violations can be CFAA violations. And oftentimes the case law has developed in a commercial context where you have two entities in a sort of commercial fight over access to data or what a competitor has done with a company's data. And so in that context, unfortunately, it has led to decisions that I think really interpret the CFAA broadly and have negative implications for the types of journalism that we're talking about. In this context, we at the ACLU brought a case known as Sandvig on behalf of academic researchers who are computer science professors at universities and First Look Media, which publishes The Intercept, and on behalf of all the journalists who work there. And we brought this lawsuit as a pre-enforcement challenge, meaning that nobody who's a plaintiff in this suit was facing prosecution by the federal government, but nonetheless, the fact that they could be prosecuted under the CFAA for the activities that they were going to conduct in the course of their research, this was the injury they're suffering. And in addition to our plaintiffs, as Surya and Alex have talked about, we know that there are many journalists out there who refrain from the research they would otherwise do because of their fear of the CFAA and what it would mean for them. And so we brought this challenge as a constitutional challenge, and primarily we brought a First Amendment claim that the activities that the academic researchers and the journalists at The Intercept want to do are constitutionally protected. They can't be made criminal by the CFAA. And specifically, we focused on two aspects of what journalists and data journalists have to do. One is scraping. Scraping, as Surya talked about, is an essential part of being able to gather enough information to have meaningful conclusions about algorithmic outputs. And then the second aspect is prohibitions on providing untruthful information. A lot of websites have terms of service that say you guarantee you will provide only truthful information. These are often real name policies, for example, which if anyone who's been on Twitter or Facebook or any social media platform knows that there's a ton of parody sites, there's a ton of people tweeting and messaging under alter egos. Clearly not a restriction that's often enforced, but nonetheless, there's the CFAA prohibition that does exist and can often scare journalists. And I'll talk about the research plan of two of our plaintiffs in particular, just to give an example of why the prohibition on false information in particular is a real limitation. So our plaintiffs, Alan Mislov and Krista Wilson, are computer scientists, and they want to do an experimental audit of hiring websites to see whether they rank candidates for jobs differently based on race, gender, age, other statuses that are protected under the civil rights laws. And to do this, they need to be able to run essentially a controlled experiment. They need to be able to see what a job seeker who is coded or appears to the site as, let's say, male, how that job seeker is treated as compared to an identical job seeker who's coded as a woman. And for a variety of reasons, you need to be able to have this kind of controlled experiment to see that it's really the gender differential or the race or age differential that's causing the different treatment, as opposed to differences in their actual qualifications or life experiences. This type of audit test is very similar to what's long happened offline to test for housing and employment discrimination. Courts have long recognized that the kind of deception involved in offline audit testing when, let's say, two actors of different races go to a landlord and seek to rent an apartment, that kind of deception is, necessary for that kind of audit testing. And similarly, it's necessary online. And if the websites say that you can't create a tester profile with anything but your real name and your real information, obviously that kind of testing just can't happen. So we've made this claim on First Amendment grounds because this is clearly socially beneficial research. Not only that, it's essential to enforcing civil rights laws online. If researchers, if journalists can't do this, there's no way to know if the existing civil rights protections in the Fair Housing Act and Title VII, state and local protections, if they're actually meaningfully being followed online. I want to also emphasize that because we're talking about the kind of journalism that could lead to outcomes that not only make a company embarrassed, but could potentially subject them to liability if they are violating civil rights laws. That is why I don't think it's an answer to say that you seek permission. Even if you prove you're a journalist, a private actor, a private company might have all kinds of reasons that they don't want to let you do the kind of test you want to do. It could actually open them up to liability. So, this is again another reason why there has to be room in the law for this kind of oppositional research, oppositional journalism. So we brought this lawsuit, and we're currently in the process of litigating it. The district court issued a positive decision early on in the case saying that scraping is not a violation in the terms of the CFAA, and essentially dismissing that claim by interpreting scraping out of the CFAA. So I think that was a very positive decision. It's not binding if a company still wants to send a cease and desist letter, to a journalist who's scraping, but nonetheless, I think since this claim was raised in the context of the kind of journalism we're talking about, it was an encouraging decision from the judge. We are still going forward and litigating the claim on behalf of the researchers who need to provide false information, making a First Amendment argument that type of falsehood is protected, and that the federal government could not prosecute them simply for lying when there's no intent to commit fraud, when the lies are not done for commercial gain. Sort of a very narrow category of things that you maybe could render criminal, but not this category. I'm hopeful that claim, we're litigating that in the district court, that will have a positive outcome. Because, as mentioned, there's the advocacy to the companies, which I think is really important, and it would be great if it became the norm not to have terms of service prohibiting journalists from doing this, and I think the name and shame is really important. But alongside that, removing this threat or this fear of criminal prosecution, I think is really important for the journalists who don't have the institutional backup, or for the institutions that don't want to risk that fight.
Yeah, and so I think as a media attorney, Aisha, your case at the ACLU, sort of let us all exhale for a hot second. We were all like, okay, that's good. Like, maybe they won't be thrown in jail today. And similarly, in the Ninth Circuit and in California, there was another case, HiQ versus LinkedIn, where there was a company that scraped a bunch of data from LinkedIn and then was creating an app that showed employers when their employees were going to jump ship and leave and look for a job somewhere else. And they brought an action in California and to sort of say, like, can you just rule, judge, and say that this is not a CFAA violation? And similarly, that case had a positive outcome. And so those two cases, one in California and one in New York, now on both sides of the coast where there are a lot of media companies and where there's a lot of technical activity, made us, I think, feel a lot more calm advising our journalists that perhaps in certain circumstances they could, go out on a branch and sort of take a few more risks and produce this important journalism that has accountability about corporations that are holding more and more and more power today. But I wonder, Sri, if you can sort of jump in here again and sort of, we'll open it up for comment, but there's legal advice that you're getting from your attorneys, and it's our job to scare you and then make you feel better. But also sort of in your own positioning, what are some of the rules and thought processes that you guys are thinking about in terms of how you approach these problems, independently of legal advice?
I mean, the biggest thing we try to do is be as transparent as we can and not be deceptive. So we try to, if we're scraping a website, like we're scraping Facebook, there's a lot of, I'm sure you can both talk about this more, but we talk a lot about like adding like a header, an HTTP header in a packet, basically identifying us as journalists. So someone went through the logs, they could see, it's kind of like telling someone that like, hi, I'm from the markup. We're doing that in code, and we think about stuff like that we can do on a technical level. But I mean, the biggest thing we do is we just talk to the companies. Right, so when we do investigation, we try to send the companies our findings.
And is that always your role? You always?
Almost. I can't think of a time when we haven't done that. If you're reporting on a company and we have found a harm that they have caused or that's happening on their platform, we always reach out to them for comment. The problem is that
That's after the fact, though, right?
Yeah, always after the fact. Yeah.
Oh, that's an important choice.
Yes, thanks. Yeah, but we always reach out to them, comment, saying that this is what we did, this is our findings. But again, you end up just talking to their PR people. You don't actually talk to the engineers, and often a lot. Like there was actually this amazing moment with the people you may know investigation, where we got to write a story with the headline, Facebook doesn't know what it's talking about, because we sent them our findings and told them about what we found with our tool, and they said, oh yeah, you can totally turn this off. You can just go to your privacy settings and say that no one can find me. And that tool, that setting didn't exist for people who weren't deemed public figures. And the PR person didn't know that because it changed in the software with the engineers, and they said, oh yeah, you're going to want to call us. It turns out we inadvertently lied to you. And like I've never actually had that happen again, but it's kind of just to Isha's point about how, like, my job isn't to like ask for their permission, it's to be adversarial towards them in a kind of healthy way. And I think having the confidence to do that requires a foundation that, like, it's basically what we do it right now, where like, like, please don't, like, please let nothing bad happen, or like we haven't punched up, I think, high enough that we've seen the claws yet. And I think that's kind of where we're at in this game, but it's coming at the rate we're going.
Yeah, and I mean, anecdotally, if you're saying please, I mean, I've heard definite number of freelancers who've just not written the story, right? Just not written the story because they don't even want to take the risk. And regardless of what the state of the law is, which I think is really interesting, and regardless of all these sort of roundabouts of what you can do.
Can I jump in on that?
Yeah,
so
please.
when we started this project with respect to Facebook, before we sent this letter to them, we reached out to a couple dozen journalists, from freelancers to people who work at the largest media organizations. And we were surprised, I was personally surprised, that even journalists at the largest media organizations, the biggest names that you can think of, think about the prospect of legal liability for violating a website's terms of service. Not just CFA liability, but even just breach of contract liability, or even a lesser form of liability. If you're a media organization that relies on your Facebook account to disseminate news, which is just about every media organization today, they worried about having their account shut down,
Sure.
which is something that the law has a very hard time at getting at. Setting aside these other, more monetary, penalties or jail time penalties you may face. And so even the ones at the very top, worried about this, and some of them have gotten a little bit more aggressive over time, over the last 6 months to a year, in part because they, I think, have learned from the markup and ProPublica's intrepid work when Surya was there and Julia Angen when she was there, that is the future of journalism, is studying the effect that large technology companies are having on society. And you can't do that work without violating terms of service, because we've gotten through the low-hanging fruit stories. We've told the stories that can be told on the basis of more traditional forms of journalism, interviewing people, finding documents and studying them. Now we have to start interrogating the algorithms themselves, and that you can't talk to those in the same way that you can talk to a source.
Yeah, and it's almost like I'm hearing two levels, right? It's like you're interrogating the algorithms, and then you're also dealing with like the bureaucracy of being like, punched from one department to the next. And do we talk to the PR person? Do we talk to the engineer? And so it's just so many levels of what is now sort of like the new state, right? Like the new government, and this is where all of our information is being held and all this sort of layers.
And just to that point, the one thing that I think that we think about a lot, especially the markup, is it's our job to make sure that these questions are in the public sphere, so that, like, for example, when the government is asking the CEOs of these companies what's wrong with them, we have good questions to ask them with evidence, right? Like when like this is based on the state of affairs right now. If you said in like 2014 that a reality TV star is going to be the president of the United States, and there's going to be evidence that there's interference from an external government, and it's going to be through the social media platforms. So you ask that person, do you think those social media platforms would have to share data with the government? You would assume the answer is yes, right? But because of the way everything's structured, our inability to ask good questions, we can't actually get past their kind of legal protection. And I think that's what, as journalists, we constantly think about.
Yeah, thank you for bringing up that point. I think that's great.
And the first reporting on Russian interference on Facebook, I think, was based on Facebook's disclosures about the number of accounts that may have been exposed to ads or other posts that were promoted by Russian state actors. And that initial reporting was shown to be false by researchers at the Tao Center, Jonathan Albright and others, who, on the basis, I think then, of using tools that did not violate terms of service, but nonetheless were able to show that all that what Facebook had been disclosing at the time was false, and that tens of millions of accounts had been exposed to Russian interference, and that was on the basis of journalism that increasingly is, subject to contractual control by these technology companies.
Yeah, which underscores the importance of your work, and I hope that this instigates other companies to perhaps at least adopt a safe harbor and potentially maybe create a trend of some sort. I do want to open it up. Does anyone have any questions for this esteemed panel?
Hi, my name is Carol. Thank you very much for sharing your insight. My question is not about the government or the big tech companies. It's actually about the people in this country, right? So European Union seems to have more strict data privacy law, and versus in China, the big tech companies and the government owns everything, right? So where do you think our country is going in terms of personal data privacy?
I'm happy to, or you go for it.
Well, I mean, I'll just say from it's not fully related to, the CFA in total, but I will say that I think that from a media law perspective, we've seen a lot more challenges brought on the notions of privacy. I think that there's a trend growing in terms of people thinking that there are protections for privacy that, let's back up here for a second. As we know, right, in the United States, there is no federal protection for privacy, and this is a state-by-state regulated thing, whereas in Europe, that is not the circumstance. And I think that we've seen an increase in concerns around privacy from the public, given the social media companies. And I think, one thing to just keep in mind that does relate back to this, which is journalists do have rules of ethics and beyond their legal measures that are in place. There are rules around ethics and just in general concerns about how they treat information. So as Jason knows well with redactions, right, you get documents, but that doesn't mean that you necessarily publish them wholesale, right? You take into consideration what's being put in there, and sometimes a journalist will only publish part of the document, right? It's not mostly, we're not a WikiLeaks environment or industry. So I think that while there is an increasing expectation of privacy, the law doesn't fully reflect that. And I do think that those things are in tension with each other somewhat right now. States are creating more privacy protections, and I'm unsure of where it might go, but that tension has always existed with the media, and I think the media takes those things into account.
I'll just add one or two things to that, if that's all right. So I think it's very hard to predict what the general privacy law is going to look like in this country in 5 or 10 years. There are efforts at replicating the regulatory regime that has now been put in place in Europe. So now Europe has the General Data Protection Regulation, the GDPR. There have been some bills introduced in the US Congress that resemble aspects of that bill. None of them have come up for a vote or really are beyond discussion drafts, but it's conceivable one of them will be adopted at some point. The First Amendment has a role to play in that sort of regulation in the US. That is not really the case in Europe, where there are the protections for free speech are not as robust as they are here. But as a practical matter, it may be the case that technology companies who wish to comply with the GDPR, but who do not want to have an extremely federated set of rules, will just come up with one set of rules that complies with the GDPR and apply them across the world. And so we may, benefit from the GDPR in that sense. The other thing I'll point out, though, just since we're talking about journalism specifically, is that the GDPR does have carve-outs for journalism and research specifically, and it encourages member states to draft exceptions to the general privacy protections that the GDPR requires for journalists and researchers, so that you don't have a situation where a company, or a law meant to restrict a data aggregator or someone else who wishes to kind of profit from data collection is being applied equally to a member of the press or a researcher who's trying to explain to the public, something of public interest.
Yeah, and I'll just add on to that, Alex, that point that I think because it's so new and the implementation is still in the works, I have heard from researchers and journalists in Europe who are saying that right now they are refraining out of a fear of violating GDPR, because I think, they have a sense that their concerns weren't entirely taken into account, or it's yet the details of what Alex is talking about are yet to be fleshed out. And so even this spring, talking to some of them, they were saying that they don't have a CFAA issue, but now some of them are concerned about violating the GDPR and whether what they're doing would count as a safe harbor.
Yeah, I should have said that only a couple of states have so far considered or enacted legislation that gives meaning to this exception for journalists and researchers. I think maybe 5 the last time I looked.
Hi, thanks. I have a sort of question about scraping, part A and part B. What are the legal and ethical issues that you guys see around, one, use of proxies? Does that create more peril or more exposure? Or number 2, actively versus passive terms of service. Like, I go to a website without having to log in. It's just publicly there, and I scrape it. But there's a terms of service that says, no scraping, and you can't wear red while you're scraping our site. Or number 2, like going in and having to check a box and say, I agree to your terms of service.
Do you want to start?
Yeah, I'll take the legal side of it. The practical side I'll let Suri answer. But I think that, unfortunately, the way the state of the law is, there is potentially increased risk with something more active than passive. So Vicki mentioned, the Ninth Circuit decision saying that, terms of service violations alone shouldn't be CFAA violations. Unfortunately, that same circuit court in a subsequent case involving Facebook said, well, the situation's a little different if the written notification was directed to you personally, if it was essentially a cease and desist or a you journalist X must stop. Okay, so we've got that, now there's a distinction between written terms of service that apply to everyone versus a written, term that, is just sent to you individually. And how that maps onto technological workarounds, I think, is still in flux. And it's sort of, there may be courts that would see, for example, masking your IP address a little differently than other courts, right? I think this part of the law is so underdeveloped, and the notion of what constitutes hacking is still in flux. So again, I think, in those circumstances, I would always suggest, getting legal advice when you're talking about more active circumvention. Again, not saying that it would necessarily, you wouldn't have constitutional arguments in defense of that, but our case is dealing only with terms of service as written, and there has been this sort of fuzziness in the law, especially even in the Ninth Circuit, involving personally directed, revocation of authorization.
There are other things there are other factors that, like, how much damage have you caused to the site? So, for example, in some circumstances where there was scraping, it shut down the site for a little bit, right? And so you want incremental type of approaches have better legal protection. There are a few other factors, but it also depends on jurisdictionally where you are as well.
And also, they don't know. They just don't know. Like, there's so many people going to their websites, and if you're doing this in like a professional way, it basically looks like Amazon is scraping your website because everything is hosted on Amazon. So in terms of who owns what IP addresses and mapping that to like the markup or ProPublica or whatever, it's all going to happen after the fact. And they're going to look back at the server log. So it is like, that's why we end up doing this, because it's like they really have to be like out to get us to do that. And like they couldn't even do that for the Russian hacking, right? So it's like in terms of the scale of the stuff we're talking about, like trying to figure out that my program is in an automated way going to like my profile probably, or like 10 profiles in a thing that has 2 billion profiles is just very hard. It's like a hard problem.
I've also heard, like, off the record from attorneys that represent these companies, right? They don't want to bring a lawsuit against a journalist. And to be clear, there has been no case brought against a journalist. A journalist has not been prosecuted under. There have been letters sent. There have been demand letters, right? There have been takedown, all these things, but there has been no prosecution of journalists or cases brought against journalists. So it's just this impending fear because the risk is so high, the potential to going to jail, right? But, you know, I have heard off the record, Facebook likes journalists, so do a lot of other tech companies. They, on paper, really like them, and they don't want to be seen filing a lawsuit. But the question is there going to be that one article? You know, it's my lawyer time, so I'll just think of the doomsday situation. Is there going to be that one article that just really, you know, makes a company mad because you really put them in a pickle? And is that going to be, you know, enough that they'll bring a CFAA claim? Is the worry.
Thank you for coming here. I have a question related to the scraping as well. You mentioned, Ezra, that there's some states and some courts that are more willing to accept that the breaking of terms of service is not a CFA violation. And you mentioned California, and did I understand correctly that New York is also safer place? Can you tell a little bit more which states allow more and which are the most awful?
Yes, so our case is actually in DC. It's in the District of DC. So it is the Ninth Circuit, which has jurisdiction over a bunch of Western states. I should say, though, it's a little bit complicated when you're talking about jurisdiction. It's not as easy as just saying, well, if I am physically present in this state, I'm covered by this decision because it's the internet. So it may depend on where the company that you scraped is located, where the claims would be brought, if they would be brought. So unfortunately, I can't give you an easy answer and say, these states it's safe, these states it's not. I think, as Vicky said, the greatest protection is there hasn't been a suit filed, civil or criminal, against a journalist for journalism activities. And because in our case in the District of DC, in this context of journalists and researchers bringing an affirmative suit, pre-enforcement, as we call it, the judge, you know, interpreting the CFAA to exclude scraping, I think that is a decision that if anyone were facing, you know, a legal claim from a company that was unhappy, a journalist could point to that and say, actually, you know, the CFAA shouldn't even cover scraping if it's in the terms of service.
It's worth also noting that some of these companies have venue provisions in their terms of service that could affect where any lawsuit would take place. And so that just complicates this jurisdictional analysis.
Hi, I wonder if you could comment a little bit on where some of the issues you're talking about sit in the, it's a two-part question, in the framework of legal education. Do they teach courses in this at Harvard Law School? And the second question is, could you comment a little bit on advocacy or lobbying efforts to alter the CFAA to make it more journalism friendly, perhaps?
Yeah. So on the first, there are increasingly courses being taught about internet law and the relationship of it to things like journalism and research, but it's relatively new. At Harvard, for example, you mentioned there's the Berkman Center, which does a lot of internet law and policy, and you know, the law school faculty members who are at the Berkman Center teach courses about internet law. and more the CFA comes up in those courses. In terms of advocacy, there has been advocacy around the CFA for a very long time. Probably the most significant kind of start to the advocacy was after Aaron Schwartz committed suicide. He was a digital rights activist who was prosecuted under the CFAA for having, I think the main charge against him was based on physically accessing JSTOR, which is a legal, not just legal, a journal, online journal, accessing their server to acquire articles and make them free for people to access. He was prosecuted under the CFA, and during the prosecution, he committed suicide. There was a huge effort then to get the CFAA amended, and it's kind of been continuing since. A lot of people have recognized the problems with it, but for whatever reason, there hasn't been a ton of traction in Congress.
And adding on to that, I think the early years of CFAA reform efforts were largely driven by the security research community, and they have long recognized the problems with the CFAA and have been very vocal about it. But I actually think what's been different in the last few years is now you've got the journalism community engaged, and now my hope is increasingly the civil rights community, because like I said, you cannot audit test for civil rights enforcement online without fear of the CFAA. So hopefully if there's a broader coalition, it would make CFAA reform more of a priority.
Yeah, so it was the Electronic Frontier Foundation in California that really led the charge on this after Aaron's death, and they have been doing this for a while, but as Aisha says, I think that the community is sort of expanding, and so they often they not only petition Congress, but then also would add to amicus efforts in all of these cases, and now, those amicus groups are getting bigger, and so there is more wind under the sails for sure.
For one more question, there was a hand earlier. Yeah.
Hi, thank you so much for tonight. I have a practical and legal question. What happens if a journalist inadvertently gets his hands on personal identifying information through scraping or through FOIA requests being processed sloppily? Or how do you kind of handle that information? Do you try to write your code around it? And then legally, is there increased liability for even an inadvertent action like that?
Want to start on the
Yeah, I mean, it's pretty easy for us because usually the kind of analysis or data collection we're doing isn't about individuals. So if we do collect that, you just ignore it or don't save it, and we definitely don't make it public. We never do that. But but for example, if you're scraping your own Facebook profile, you will see the news feed which has other people's information. So you kind of can't avoid it to some extent.
Yeah, go ahead, Alex.
No, please.
I think that this is something that newsrooms often take into account, right? If you get something from FOIA, the notion is that it's a publicly available document, and therefore it can be published. But even in small, some discrete cases, we've chosen to redact emails of people, phone numbers, addresses, because sometimes it's just unnecessary, and we're cognizant of those things. And so if it doesn't have to directly deal with the story at hand, we will happily redact that information. ProPublica once did also a very smart move where they got slides from a company, and then they ended up just recreating the slides to protect their source instead of putting them, because not only is the problem with the data that you see physically, but there's metadata, right? And so we are now very much in newsrooms thinking not just what's on the face of the document, but within the documents themselves and what that might reveal. So journalists and attorneys all the time in newsrooms, I mean, that's a daily conversation we have, especially when you're dealing with reporting on children or sexual assault, immigrants that could be named, right? So all these things are taken into consideration. I know of one particular story where a photo was published by a news outlet, and then they ended up seeing from the photo where the GPS of the story was taken, and from there a source was located. Right, so all these levels now are being considered of what information is being published, who is being put at risk, and we always think about, do little harm as much as possible.
On the legal side for scraping, most of the scraping that's done is of publicly available information, public sites, because that's what you have access to if you're not logged into the site with credentials. And so the legal question then becomes the same as the CFAA question. The fact that some of this publicly available information may relate to an individual or be personally identifying doesn't change the kind of legal analysis under the CFAA. It'll certainly influence the atmospherics of that litigation, and a company would have a stronger atmospheric argument that the CFAA is serving an important purpose by allowing them to punish the collection of personally identifying information. But the legal question, I think, is the same. Under FOIA, one thing that you sometimes see is the government trying to claw back information it has given. Jason referred to this earlier, and it happens not infrequently where the government will accidentally disclose information. If you're not yet in litigation against the government and they've released that information to you, you're pretty free as a legal matter to do what you want with it. There may be some circumstances where maybe it's national security information that the government could make an argument that you're liable or that you would be liable under the Espionage Act for disclosing it. If you find yourself in that circumstance, I would love to talk to you because it's a very interesting issue. If you're in litigation, the government has generally been more successful in getting the court to force FOIA recipients to turn back over that information that it accidentally disclosed, although that issue has never really reached high courts. I know when I was at the ACLU, we had a couple of circumstances where the government accidentally disclosed classified information to us. And in one of them, the deal that we struck was, we're not going to give it back to you, but we will agree to abide by whatever the court says. But now that we have access to it, we're going to make arguments about why we think it was improperly classified based on our knowledge of it. Whereas normally you're making arguments about classification blind because you can't see what's there. And we thought we had compelling arguments for why this information shouldn't have been classified. They were the criteria that the government used to classify, I think, Afghan detainees as enduring security threats, which subjected them to indefinite detention. And the criteria looked like law to us, and we thought they wouldn't reveal anything, that the government shouldn't reveal anyway. But we lost, and we turned it back over.
Well, I think that wraps us up. I just want to say on behalf of the Tao Center, I wanted to thank all of our audience and, of course, our wonderful panelists, Aisha Bandari, Surya Matu, Alex Abdo, Jason Leopold, and, of course, our author, Vicki Baranetsky, for coming out tonight.
Thank you all.
And just a note for those of you who are here with us physically, we have a few printed copies of the report that you're welcome to take. If you're watching online or just want to reference it later, the entire report is available on the Columbia Journalism Review website, and also for sort of archival purposes at the Columbia University Library's Academic Commons. So if you just search for data journalism and the law, you'll find an archival copy there as well. So thank you all again and have a wonderful evening.
Thanks.